Good afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to tell you if it's possible to receive citizenship in the United States or naturalization without having a knowledge of English language. Meaning that can you become a citizen if you do not speak English? Well, surely you can, but in very, very limited circumstances. First of all, children who are permanent residents and who are minors, meaning they're under 18 years old, at the time their parents become citizens, automatically become citizens. So, and it doesn't matter if they speak English or not. That's number one. Number two, at times, depending on your age and how long you resided in the United States as a permanent resident, you may be able to take English test exam, an exam on United States history in your own language. It means that you still need to know answers to those 100 questions on a naturalization test about United States history and the United States, the way the United States works in terms of government. You still have to know those answers, but you will be accommodated and you will be able to pass that exam in your own language. So when is that applicable? First of all, let's say if you're 50 years old and you've been residing in the United States as a lawful permanent resident, you had your green card for 20 years, then you'll be able to become a citizen even if you do not speak English, because you will be able to pass those necessary tests in your own language. If you are at least 55 years old and you've been residing as a permanent resident in the United States for 15 years, now not 20, 15, so they shave off 5 years, also you will be able to pass the test or take the test rather in your own language. And that's about that. Now, the main exemption. There is one more very rare case when you can become a citizen of the United States and you do not have to know English, and you will be exempt from knowing facts about the United States history and the way the government works. If you are found to be medically exempt, if you can demonstrate that some sort of medical condition, psychological condition prevents you from learning English. How do you do that? Well, it's actually not you really who's going to be doing that, but it will be done by a medical professional, a doctor, a licensed individual who is going to conduct certain tests, or perhaps it's your treating doctor who is going to submit a special form, an affidavit, sworn statement, attesting to your conditions, explaining how your condition prevents you from being able to learn and memorize English. That licensed individual will have to state that, will have to have grounds to state that your condition lasted or is expected to last at least for 12 months. So how does it work? Well, you will have to present that form. It's form N648, 648, together with your N400 application. In certain situations, USCIS will still accept the form, the medical evaluation, even if it's submitted later, after the time you submit your N400. But nowadays you have to explain why you didn't submit it together. Also, if you present multiple forms, you have to explain why it's happening, right? Why there is not one form. I'm going to tell you why usually it's happening. It is because that form has to be perfect. A USCIS officer cannot challenge the medical diagnosis, but they can challenge the way the form is filled out. So if that medical professional is making a mistake on the form, not because you don't have a condition, but because they couldn't explain how that condition relates to your ability or inability to learn English, how it affects you, if it's not, if it lacks details, the form will be rejected. Not only that, but you also can be sent for an examination to the doctor that USCIS will choose for you. Okay, so nowadays that form is scrutinized heavily. It has to be done by a professional who is maybe your treating doctor. That's the best case scenario if that's the case, or it's somebody who has a background in performing this sort of evaluations and is a credible person who's not just writing whatever you ask them to write, but actually knows the tests that need to be performed. Usually they are non-verbal tests, and does a quality, reliable, true work that USCIS can rely on. So that would be the only other way for a person to become a citizen, naturalized, if they do not speak English and cannot learn it. So what happens in this situation? What happens in this situation is that a person will still be asked security questions, but will be exempt from English tests. They don't have to know how to write or speak English. And history portion of the exam will be waived as well, but the person will be asked other questions, where they lived, if they work, if they committed any crimes, lied ever on forms, and things like that. So security questions will be given to the person in their own language. Now, interestingly, if the person works, has a job, it doesn't mean that they will automatically be disqualified from receiving medical exemption, because that medical exemption, it depends on the condition, on medical condition, that on the diagnosis, what's going on in the person's body, in the person's head, why they cannot learn. A person can still work performing very simple functions, let's say at work, something that they learned long time ago, but they may not be able to learn new things related to language. So it's still possible, but again, it's not a lawyer who's going to determine that, only a doctor, and it has to be a licensed professional. So that's, now you know what can be done if you do not speak English, cannot learn English, and it's confirmed by a doctor, and that there is still hope to become a US citizen. And you can learn more about immigration on our website, www.shautsova.com. Thank you.